Thanks for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program. We are coming to you live from Washington, D.C. Our webinars are every Wednesday and are provided complimentary. They're recorded and can be downloaded from our website and YouTube channel, which now holds over 300 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for our speaker, we will have his information on the last slide of the presentation today. A special thanks to our educational sponsor, the National Veteran Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. And now about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. Also, this Friday, April 17th, we will be hosting a COVID-19 contracting for federal and state government funding and business opportunities. Please visit our website for more information. We also have opportunities for your organization to advertise in our newsletter. We now reach over 17,700 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. Now to introduce our speaker, Tony Anikeff. Welcome, Tony. We're glad to have you here with us today, and I'll turn the floor over to you.
Thank you very much. I appreciate Jennifer and team sponsoring this program, and it's always a pleasure to be part of it. I am Tony Anikeff. I'm a partner and coach at Williams Mullen, and I'm a co-chair of their government contracts practice and also involved on the COVID-19 response team. Next slide, please. Today's program is going to focus on creating a sound legal teaming agreement, and I want to thank all of you who are taking time out of your day to join me in digging into the niceties of creating a proper and perhaps enforceable teaming agreement. Considering the unusual business environment in which we all find ourselves, I did want to start by saying that I hope you and your colleagues and families are all faring well in these unusual environments. Although this is not a COVID-19 related seminar, with some of the rapid fire deals that we have been advising on over the last few weeks, some of the lessons that may be learned today may be helpful. Next slide, please. So what we're going to cover today will be to focus on what constitutes a teaming agreement. What's it all about? How it should fit into the business continuum of getting business, and whether you should team at all. What a teaming agreement should look like. What are the key issues in enforceability? What are the different types of teaming agreements? And by that I mean what most people would think of as a traditional teaming agreement that's vertical in nature between a prime and a sub, and the horizontal teaming agreements, which are more in the nature of a joint venture. I would note that although this program is focused on the government contracting community, it also applies in many ways to teaming in the private sector. Next slide, please. So what is a teaming agreement? Because we're in the government environment, let's look at what the FAR says. And the first thing to know is that the FAR doesn't define the concept of teaming agreement. In common parlance, it's essentially a document that memorializes one's arrangement between two entities. What the FAR does do is break out two types of contract teaming arrangements. One, as I mentioned before, is the horizontal type of arrangement, which we'll talk about in a minute, which is really a joint venture, which could be a partnership, an LLC, or a corporation. It's formed for a specific purpose and carries out under terms like a freestanding corporation. The other is a vertical teaming arrangement, which is a more traditional concept of two companies or more getting together with a prime and a subcontractor to also engage in specific purposes. As a matter of policy, the FAR is pretty wide open, and it'll recognize either of these types of teaming arrangements under two conditions: that the parties be disclosed and the relationship be disclosed either in the offer or before it becomes effective if a teaming arrangement comes together after offers are submitted. Turn to the next page, please. One other distinction we want to draw is the difference between a teaming agreement, which is what we're talking about today, and a subcontract. The FAR defines both a subcontract and a subcontractor. And the goal of the teaming process, of course, is to end up with a subcontracting agreement at the end of the process. The key is that a subcontract is the agreement enforceable by which an entity provides goods and services to a prime contractor in fulfillment of its prime contract to the government. That ties in with the definition of a subcontractor, which gives some consternation to suppliers and distributors when they find out that any supplier, distributor, vendor, or firm that furnishes supplies or services to a prime contractor might be considered a subcontractor under the FAR. It's not within the scope of this particular program, but there are many vendors out there, hardware stores, big vendors of roofing equipment, things like that, who are surprised to see that maybe the FAR does apply to them. Next page. So let's jump in and start focusing on the teaming process itself. I will say that we're often surprised by the calls we get when we're asked simply to draft up a teaming agreement, just because that's the way it's done. And what we find is that the prospective client really is given very little thought to the why, the purpose, and what they're entering into. Whether one should enter into a teaming agreement or why one should enter into a teaming agreement and what it will look like really should depend on the application of a number of factors that a business person should consider and discuss before proceeding. On this page, we've set out a number of those factors, from the basic to the more nuanced. At a basic level, the framework that one is going to enter in under a teaming agreement often depends on whether you're the prime or the sub, whether you're large or small, whether you're experienced or new entrant, or whether you have particular leverage because of a unique product or skill. That's at a very basic level. There are lots of reasons why people should enter into a teaming agreement. We've set out the pros and cons here. They fall really into two categories. The first category, which is really the first 5 lines under the pros, are to expand capability or capacity to meet the requirements of a customer or enter into a new area. In other words, you might be teaming because somebody else has some unique experience. They might have a tie to the customer. They might have some unique past performance and the like. So that's an expansive approach. The second one is much more defensive, the last 2 lines of the pros, and that's really to reduce risk or share costs, or in some instances to lock in a partner. There it's much more of a defensive approach, thinking about how to protect oneself. On the other hand, there are some cons of why you wouldn't enter into it. First, you certainly have to give up a lot of internal control. You have to give up the opportunity for organic growth. And it might be that you could develop these skills or capabilities internally by yourself, and therefore not have to share in some of this with another entity. You give up control and you give up profits, and you put your secrets at risk by having to share them. And lastly, you might be creating a competitor who will be a challenge to you in the future. For the smaller entities, a particular risk is that you might put in lots of effort, because these teaming agreements often require a substantial investment of time, and find out that you get shut out at the end of the process if you don't play it right. Next page, please. So it's important, as I said before, to think about the teaming agreement process as a continuum. As you look on this page, it is not at the top of the list. It's pretty far down. And you need to be thinking about a teaming agreement as part of your continuum in applying these factors. One needs to put the teaming agreement into the context of your overall consideration of your business goals, which are going to vary from circumstances, depending on your role, your size, your plan. So the first question is whether you need to team at all. Can you develop the product or the service yourself? Can you go hire a new set of employees that would be helpful? What are the respective consequences of going alone or teaming? They're obviously different ones, and that's something you think about before you go down this road. What is the business deal or business deals you are chasing? Is it a one-off deal, or might you be setting up to go after a series of deals or an entire program over a period of years? That ends up with a different looking document where you're going to have a multiple set of subcontracts that are probably going to spin off. So it's important in making these considerations, don't just jump in. Before you do that, even if you've met some company you think that's ideal, it's worthwhile doing some market research on the company that you're thinking of teaming with, and then going to seeing if there are other companies that might be just as helpful and might be more compatible the way you do business in considering how to do it. What are the secrets that you're going to have to share? Are you going to have to enter into an NDA, which is really a critical first document you need to agree to before you get too far down the road? You need to decide what that NDA is going to look like, how long it's going to continue, and it too is not just a boilerplate document, but should give some thought to it. It's important to do due diligence. Even in this time of social distancing and isolation, it's possible to do research on SAM and Dun & Bradstreet or its replacement. It's possible to interview your teammate and see what it's like. You can have a Zoom conference and interview. I will share with you that a week ago, we were working with a company who received a proposed subcontract in a situation where they hadn't even done a teaming agreement, and it was a draconian subcontract. We went back to the other side with some changes, and it came back in an even more draconian manner. We did some due diligence and found out that there were 3 current lawsuits for them failing to pay their subcontractors. The catch is that they have a unique entree into a particular agency. So it's a delicate balance that you have to go through in deciding whether to team with a particular party. So hopefully, if you go through that process and you decide you're going to enter into a teaming agreement, we can move on to the next slide. So the first type of teaming agreement we're going to talk about is the vertical teaming agreement, which is this traditional prime subcontractor arrangement that comes together most often in the marketplace. So although they are somewhat similar when you look at them, each teaming agreement should be unique in reflecting the unique circumstances. So there's no cookie cutter solution. And those that do them find out that they run into the problems that of enforceability and the tensions that we're going to talk about. In one of these agreements, each party retains its identity as a company, and it sets up as either a prime or one or more subcontracts, each with their own interests, each with their own goals. The goal, however, of a teaming agreement is that there will be a prime and a subcontract that will join forces to get business, and then in theory, the prime will give the subcontract a portion of the prime contract to work on. I use the word in theory because the source of most disputes and litigation in the teaming agreement arena is when the subcontractor doesn't get the work that it was expecting to get, or that it somehow gets excluded. And that is why time often needs to be spent in negotiating this. Most simply, most folks don't think through a teaming agreement as much as they should, and it should involve some negotiation to address the unique circumstances and interests that you have in what you hope to get out of it. If I were to generalize it a bit, most primes want flexibility to delay or escape from a teaming agreement or to switch horses as the process continues. Subs usually want to enforce or tie down the prime contractor to commit to work. Having said that, however, the circumstances of a prime may change dramatically if the subcontractor they're dealing with has a critical technology or critical personnel or critical past performance. An example might be a business that has developed a very close relationship with an agency that is now issuing the follow-on program as a small business set-aside. The company can no longer go after it, so it might team up with a small business or an Alaska Native company to go after that business. It needs that entity to secure the business. Another issue that arises in the teaming agreement, particularly for smalls, is when the process gets drawn out. And if you think of protests, these processes can go on for quite a while. They can get drawn out. We've noticed in the past few weeks that the government is so eager to get into a contract that they are now doing advance agreements. And advance agreements requires the contractors to begin performance before there's a contract, and often at risk prior to the contract in which the government says it'll reimburse you but doesn't commit to do so. All of that can put strain on a teaming agreement and something that should be addressed. Next page, please. So the big challenge about teaming agreements that one reads about all the time, and that's something to be considered, is the enforceability of a teaming agreement. The fact that it's unenforceable may be fine if all you want a teaming agreement to be is a roadmap to use in planning for your mutual efforts to get a subcontract. If that's your goal, it's fine. But for many who want to have an enforceable agreement, you need something more. Then you have to look at the law which will govern your rules, because they differ across the country. For those in this mid-Atlantic region, for Virginia, Maryland, and DC, the courts are strict in interpreting the teaming agreements, and they largely require that the terms of the subcontract be locked in, or an objective standard be used for determining what they will be. In other words, you can't have an agreement to agree, or that you will terminate the teaming agreement if after 60 days of negotiation it fails. You can't have an undefined statement of work, and you can't have pricing TBD. You can't really leave significant negotiations to be conducted if the government approves. The alternative is to perhaps apply New York law. It's a bit looser. Price can be approved through a defined process that doesn't necessarily need to be as objective in Virginia as it is in Virginia, Maryland, and DC. And then to go to the other extreme, California is by far the loosest, and the courts have approved even an oral teaming agreement, but it's not unlimited. One thing to keep in mind in terms of enforceability, even if the entire teaming agreement will not be enforced, it may be possible by careful crafting that a court will enforce particular provisions of a teaming agreement if you have crafted a careful severability clause. And a severability clause says that if a court strikes down all portions of an agreement, it is the party's intent that the other portions will remain enforceable. So that's an important thing to keep in mind. All of this says that the negotiation of a teaming agreement and the choice of law can be critical and worth the effort to spend the time on. Next page, please. Okay, key terms for enforceability. Assuming one desires to enforce a teaming agreement, there's several areas that need to be addressed to increase the likelihood of creating an enforceable agreement. Ones that often forgotten is the preamble or the recital section. They're often overlooked or dismissed with boilerplate, but it is a chance to give context to the agreement and to reflect the desire of the parties and the purpose for which they're undertaking this effort. A key aspect is you need to include in your agreement itself a term that specifically incorporates the recitals into the agreement. You also need a clause that says it's the intent of the parties that this be a binding agreement and not just an agreement to agree. There also should be mutual consideration. Within the agreement itself, all of these kind of terms are things that need to be focused on to make sure that you have something enforceable. How long is it going to last? That can become important if you're going after multiple deals. You don't want it to last forever, particularly if you've entered into an exclusive arrangement. We've talked about the termination clause a little bit. It can't be a termination clause that says, we'll agree to a subcontract if we can agree in 60 days, otherwise it terminates. Those kind of clauses are agreements to agree, and the agreement will be knocked down. Exclusivity is something that is often wanted by subcontractors or a prime contractor who's looking to tie somebody in. Again, it needs to be tied to the duration and term of the teaming agreement. The subcontracting language, it needs to be mandatory if it's going to be enforceable. You can't say we'll negotiate and maybe. You have to say that it is the intent of the parties that the subcontractor will receive a subcontract on specified terms. And ideally, you'll be able to negotiate the statement of work, i.e. a portion of the subcontract, a portion of the prime contract, which you might include as an attachment. You certainly can attach portions of the proposed subcontract to your teaming agreement, all of which goes to increase the enforceability. Similarly, price. If you can't specifically agree on the price that will be paid under the subcontract, then you want to try and create an objective standard by which the price will be determined so that it's really plugging in a number rather than a negotiation that leads to that. The ideal, of course, is to attach the subcontract as a attachment or exhibit to the teaming agreement. That often is not possible by the time that you go through the process, but one can go a long way there. And in terms of enforceability, the more you put in, the better it is. I'd like to talk a little bit about remedies. Given the fact that enforcement of teaming agreements are often difficult, parties sometimes try to consider liquidated damages as an alternative to litigation, and one might come up with a value. The second theory is, instead of treating a breach as a breach of contract argument, which is often defeated, one might argue that one has breached the obligation of good faith and fair dealing, and there is thereby created a constructive trust as the measure of damages. Let's go on to the next page, please. Okay, this is the scope of agreement terms. This is how you shape it. There are a variety of terms, and often they look similar, but what you need to do is, this is going to be the document that sets out the relationship you have leading up to entering into a subcontract. And if you're going after multiple deals, will continue after your subcontract towards the second and third and fourth. So you want to define the relationship between the prime and the sub. What are the roles going to be? Who's going to take the lead on drafting? What's the subcontractor's obligation to commit resources and finances? What IP will you be accepted to share? You want to get into the nitty-gritty of the subcontract expectations and the type of clauses that are going to be involved, all right? What kind of duration do you want it to go on for? One of the issues that comes up is communications with a customer. Now, in most, the prime contractor is going to take the lead in discussions and negotiations with the government in this type of situation, but you may want to include the subcontractor in those discussions. And then there's the situations like the one I talked about before, where the subcontractor really brought the business to the table, and you've got a prime contractor of convenience, so to speak. In that situation, you may have to set up an arrangement where the subcontractor gets to have direct communications with the entity with which it has a good relationship. How you frame that out is sensitive and something that is worth spending a little bit of time on. The NDA and confidentiality are obviously critical and need to be addressed, both in terms of during the teaming agreement process and how it will flow into the subcontract. Will the NDA continue into the subcontract period, or will the subcontract have its own confidentiality provisions? Obviously, you need to deal with IP and how that's going to be dealt with if that's a sensitive issue. One thing about special circumstances where you have a critical teammate, if you have a situation where there's some critical technology or code, it may be necessary to set up an escrow to protect that code in case things fall apart. If you have a key person, how can you tie that person into the agreement and guarantee they'll be there for the subcontract? This is one of the areas for due diligence discussion early on. Next page, please. So some of these other terms, these are more of, I'm not going to say generic, but ones that you should spend attention to. You want to talk about the hiring and the no solicitation clauses. That also becomes particularly important in the subcontract. You don't want folks poaching on your folks, and you don't want to poach on others. The OCI clause is important because, as a number of our clients have found out or have asserted, there are all sorts of conflicts of interest in the government, not just because of the relationship that any one company has with the government, but based on the people they may hire with the intention of using them on the contract. One needs to be careful about hiring former government employees or employees of people who are your competitors. They can lead to bid protests, and they're something that need to be disclosed. The other thing I wanted to talk about are flow downs. One doesn't know what the actual flow downs are going to be until the prime contract's negotiated, but they will be in the solicitation. And it's worthwhile spending some time early on to perhaps include the prospective flow downs in your teaming agreement so that they can be addressed. For instance, if your prime contract is a cost plus fixed fee or time and materials, but you expect that you're going to have subcontracts that are done on a commercial item fixed price basis, then it may be possible that the flow downs that will go to your subcontract are much more limited under FAR 52-244-6, which have about 15 clauses. And you may be able to negotiate that out, at least in draft, in the early stages. The boilerplate are the kinds of clauses that are added. Up until recently, I don't think many people paid attention to the force majeure clause. It now seems to be something that everybody looks at. Again, you need to include a clause about the recitals being included in the agreement, and the disputes clause and applicable law are also important. Next page, please. Let's turn briefly to the horizontal teaming agreements, and those are the joint ventures. The issue of enforceability doesn't apply here because what you're creating is a new entity, either a contractual joint venture or an LLC or a corporation. And the type of arrangement is that partners or members, whoever's going to comprise the JV, really create an organization which is intended to follow a particular purpose for a particular period of time, and each party agrees to contribute resources and share liability in some form of negotiated share, often related to the percentage of investment or commitment to the organization. A big issue in creating a joint venture is whether the joint venture will be populated or unpopulated. People often used to have populated joint ventures in the sense that a populated joint venture means that the new legal entity hires its own staff, both the program people and the administrative staff. An unpopulated joint venture means that the joint venture can hire a small administrative staff, but the work will be done by employees of the various members. I would note that the SBA now bars populated joint ventures for the various types of approved small business joint ventures because the SBA is concerned that the small business folks get shut out of the staff and they don't get the benefit of the small business programs that they're intended to. Next slide, please. So the key terms of a JV. This is really an area of corporate law that's outside the scope of our discussion today, but it's really setting up an organization with an operating agreement. It's cut just like the corporate bylaws, operating agreement, all of those kinds of things. A key aspect, though, is to set out the scope of what the JV is supposed to do. Two companies come together to go after a certain Defense Department contract, or to go after a Defense Department program and series of contracts. One talks about the ownership interest. Who's going to contribute what? How are the profits going to be distributed? Who's going to make the decisions? Is there negative control? Who's going to provide management? It's important to address succession in these interests because even though one thinks that these entities will continue forever. It may be that one entity wants to get out of the agreement. What happens? Especially if you're in the midst of a government contract and the government likes who you are, how do you slough off somebody and bring somebody in new? Liabilities are shared in a negotiated manner. And how do you wind up and end the organization? And can you kick somebody out of an organization if they engage in improprieties and inappropriate activities? The SBA has some special requirements, and let's turn the page and talk briefly about them. So there are a number of small business programs. The one that's often used is the All Small Mentor Protege program. This has been an evolution of the SBA, and it allows an entity other than a small business can apply with a small business to enter into a program where the small business identifies its needs, the large business agrees that it will provide that assistance. It can own up to 40% of the protege. So you enter into a JV agreement that has to be approved by the SBA. You have to submit a plan to the SBA of what you're going to do, and then you have to provide annual reports. What happens then is that the small business can apply for some set-aside contracts. The large business rides along in support, and you, as a large business, can get business that you otherwise would have been excluded. There's an initial 3-year term, and with approval and good performance, you can extend it. One needs to emphasize the risk of non-compliance. There have been companies that have taken this loosely and found out to their detriment that if you sign up to one of these things, you have to go along with the rules. You have to provide the assistance. You have to provide the support. You have to allow the little company to lead. If you don't, you may be excluded not just from this program, but for other government contracting programs as well. Lastly, the Small Business Set-Aside program is similar. 2 small businesses can combine to go after 3 new programs over 2 years. Next page. The last thing I want to touch on, because it's confusing, is the GSA contractor teaming arrangements. If you're 2 GSA schedule holders, you're allowed to combine and enter into a joint venture agreement. Those agreements are online. They're form agreements which you should tweak to meet your particular needs, but you can bring the resources of 2 GSA schedule holders together. One of them agrees to operate as a managing member, but they actually are both prime contractors. It's a way to increase business. With that, let's turn to the last slide. I want to thank you for spending part of your day with me. I know that in these types of seminars where we go kind of quickly at 10,000 feet, there are often questions. And certainly in this COVID-19 environment, there are all sorts of new business relationships being developed. My colleagues and I are happy to answer your questions, both in this area and in others. And I would note that Williams Mullen on its main page has a COVID-19 legal resources page. Thank you again for your time. Good afternoon and stay safe.
Thank you, Tony, for a great presentation and sharing your time with us. And thank you to everyone who joined us. The recording will be on our website and YouTube channel within the next 24 hours. Please join us this Friday as we cover each part of the FAR, and join us next Wednesday for more hot topics in federal contracting.